We are thrilled to be joined today for the lunch and the keynote remarks by SEC Chairman Gary Gensler, who will be describing the philosophy behind the SEC's enforcement work, including during the recent fiscal year. Just a quick introduction. Chair Gensler was nominated by President Biden to serve as chair of the SEC and was sworn into office in April 2021. Before joining the SEC, he was a professor of global economics and management at the MIT Sloan School of Management. He also previously served as chair of the CFTC and was a senior advisor to U.S. Senator Paul Sarbanes in writing the Sarbanes-Oxley Act. Before all that, Chair Gensler was a partner at Goldman Sachs in the Mergers and Acquisitions Department. And as I learned from the SEC's Twitter feed last week, Chair Gensler has a twin brother, and it was their birthday last week. So happy birthday to you both. And please join me in welcoming SEC Chair Gary Gensler.
Well, thank you, Bruce, and Rob thanks you as well for wishing the two of us happy birthday. Look, I'm pleased to be here with all of you. I don't know if somebody left something here, but I'm pleased to be with you here at the forum. As is customary, and as all the commissioners say to you, we note that their views are our own. As for me, it's as my own as chair of the SEC, and I'm not speaking on behalf of my fellow commissioners or the SEC staff. I'm glad I got that out of the way for all of you lawyers, that you have that properly. But when I spoke to you all 2 years ago, and I know it was virtual at that time, but when I spoke to you, I started and I shared with you a quote from Joe Kennedy, the first SEC chair. I'm honored, and it's just a remarkable privilege to be in the same job that he was in, President Kennedy's father, for those of you who don't know enough about our history. But in his very first speech, I think it was at the National Press Club here in Washington, he said, quote, "The Commission will make war without quarter on any who sell securities by fraud or misrepresentation." It's kind of a clear, succinct line of Joe Kennedy. But in his subsequent speech, just 4 months later, up in Boston, he was going home to his hometown. He was talking to a lot of folks in the business community in Boston. Kennedy said in that speech, and it's really a stem whiner if you read the whole speech and get near the end, but he emphasized, quote, "We are not prosecutors of honest business." He was talking to this business community, and he wanted to sort of say, we're not prosecutors of honest business, nor defenders of crookedness. We are partners of honest business and prosecutors of dishonesty. We shall not prejudge, but we will investigate. These words, I think, remain true to this day. I appear here today in front of an audience of course, lawyers. Now, there may be also some of you that are compliance officers, some of you accountants and so forth that come to a conference like this or listen in at home or in your law offices. While you serve your clients, you also have a responsibility to the law and to the public. So I like quotes of some of our founding members of the SEC. William O. Douglas, he was the third chair of the SEC, and that's before he went on to the Supreme Court. He went down and he talked to a group of lawyers down in North Carolina early in these 30s. And he said, quote, "Service to the client has been the slogan of our profession." He was talking about the legal profession, which he was proud to be a member of. "And it has been observed so religiously that service to the public has been sadly neglected." Now, this is in the aftermath of the financial crisis of their day. Thus, when Roosevelt thought about how to staff this new agency, he turned to Felix Frankfurter, another person that went to the Supreme Court, as you know. And Frankfurter famously wrote in a letter to Roosevelt, in 34 this is, quote, "You need administrators who have stamina and do not weary of the fight, who are moved neither by blandishments nor fears, who, in a word, unite public zeal with unusual capacity," end quote. For any of you that visit my office, I have Frankfurter's quote on my wall at the SEC. And I do because I really think it sort of embodies the SEC, nearly 5,000 people. who have the stamina, do not weary of the fight, who are moved neither by blandishments nor fear, who, in a word, unite public zeal with unusual capacity. Recognizing what Douglas said, that many lawyers, you all have clients that are different than maybe the public servants at the SEC. And that's why we're so fortunate to have the remarkable staff at the SEC. Every day they work to advance our mission, ensure the markets work on behalf of investors and issuers, and it's not the other way around. It's that issuers and investors are working for the markets and the intermediaries in the middle of the market. It's that the market intermediaries should be working for investors and issuers. See, I don't really rank our three-part mission pari passu. It's about the issuers and the investors and markets working for them. In fiscal year 2023, our staff once again did not weary of the fight. We followed more than 780 actions, including more than 500 standalone cases. We obtained judgments and orders totaling about $5 billion, and our work led to $930 million distributed to harmed investors. These numbers, though, tell only part of the story. Our philosophy behind them really tells a fuller one. And again, I think our enforcement program through 5 themes. I've talked about these 5 themes when I was with you 2 years ago as well. Economic realities, accountability, high-impact cases, process, and positions of trust. First, economic realities. In thinking about economic realities, if you just give me a little moment, once again, I'm going to quote a Supreme Court justice. But this time, not one from the 1930s, this time Thurgood Marshall. You'll know it, it's from the Reeves case. Quote, Congress's purpose in enacting the securities laws was to regulate investments in whatever form they are made and by whatever name they are called. Quote. Now again, that's not just a talking point, because Thurgood Marshall wrote that in the Reeves opinion, that's the law of the land. Not a talking point. Thus, to effectuate Congress's purpose, we don't enforce the securities laws based on a product's label. Rather, we look to the underlying economic realities. This is true across all of the securities markets. But let me just focus on one of its sectors. Yes, you had the panel. I couldn't help it, Bruce, to come back to the panel that you just had on crypto assets. You called it digital assets. I would note that we've had digital assets for decades. Since the dawn of the telegraph in the 19th century, we've had some digital assets. But by the 1990s, I mean, like by a show of hands, how many of you get paid in physical cash any longer? So how do you think you get paid? It's a digital asset. It's called money. But I'm going to turn to crypto assets. There's really nothing about the crypto asset securities markets that suggests that investors and issuers are less deserving of the protections of those securities laws that Thurgood Marshall wrote about in the Reeves opinion. Congress could have said in 1933, 1934, that the securities laws only applied to stocks and bonds. I mean, of course, we had the stock market crash of 29. They could have spoken just to stocks and bonds. They didn't. Congress included a long list of items in the definition of security, including investment contract, amongst 20, 30 different items, comma, comma, comma. Let me just ask another show of hands. This will be a little fun. How many of you in this audience have clients in the crypto markets? Dave Hirsch is not going to take any names. How many of you? Okay, 20 to that side, 15 to that side. Let's call it 30 to 40. Okay, now let me see. For those who raised their hands, I am presuming that you know who your clients are. I presume that you entered into an engagement agreement with them, that most of you actually know what their websites look like, that there is an identifiable person that you're relying on to retain you and pay for your services you provide. I'm not asking for a show of hands, but I bet you all 35 of you, there's not somebody just here working pro bono for some distributed, decentralized, no one in the middle. Well, in most cases, that's the economic reality at hand, and as the Supreme Court said in the famous Howey decision, an investment contract exists when there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. Those 35 of you that raised your hands know the Howey test, and the rest of you probably do too. As I've previously said, without prejudging any one asset, the vast majority of crypto assets likely meet the investment contract test, making them subject to the securities laws. And I'm guessing if any of your hands went up and you're advising somebody that has a crypto asset and you're getting a signed engagement letter and your partners are counting on you to collect the fees, you too know who the entrepreneurs are in the middle. It's just like common sense at some level. Further, it follows that most crypto intermediaries transacting in these crypto asset securities are subject to the securities laws as well, with wide-ranging non-compliance. And that's what we do have in this field, wide-ranging non-compliance. Frankly, it's not surprising that we've seen many problems in these markets. We've seen this story before, and that story is very reminiscent of what we saw in the 1920s. What led Roosevelt and Frankfurter and Douglas and Landis to go and do what they did with Congress in 33 and 34? We've seen some of this before. And what is that? It's a field rife with fraud, scams, bankruptcies, and money laundering. Maybe they weren't as focused on that in the 1920s. But that's what we have here today in the crypto field. While many entities in this space claim they operate beyond the reach of regulations issued before Satoshi Nakamoto's famous white paper, by the way, it's almost the 15th anniversary. It was 2008 on Halloween night, so we're just a few days away. Who here is going to dress up as Satoshi Nakamoto on Halloween? Okay. Whoa, no, did I see a hand up there? No, okay. I'd say that though they may claim that they operate beyond the reach of those regulations issued before Nakamoto-san's paper, they also are quick to seek the protections of the law in bankruptcy court and litigating their private disputes. So they do turn to lawyers like in this room and seek, remedies under the law. We've brought numerous enforcement actions against actors in this space, some settled, some litigated. Second, let me turn to accountability. Nothing motivates individuals and firms quite like accountability. We use all the tools in our toolkit. Some of you worked at the SEC, you know these well. How do you hold bad actors accountable, both firms and individuals? Bars, penalties, injunctions, undertakings, litigating where appropriate. Accountability starts, I believe, with a robust set of allegations or findings of fact. It's nothing but the story that you can talk to the public, and the public benefits and justice benefits with a robust finding of facts. The allegations and finding of facts convey to market participants, many of them your clients, what about the action crosses the line. While the press often reports on monetary remedies, accountability also is about the undertakings of the commitments of firms to update their procedures or retain independent compliance officers. It's just one example. I promise it won't be crypto. Just one example this past year, the Options Clearing Corporation. As you might know, it's a systemically important clearinghouse. It's the big derivatives clearinghouse in the securities markets. Provides services for market stability. Yet the OCC violated its own rules, putting the markets the OCC serves at risk. This is unacceptable. In holding the OCC accountable, we not only penalized the firm, but required it to revamp its risk management for sure. Of course, monetary remedies geared and appropriate to the circumstances are also important. I'm not going to say it's only about telling a good narrative, the finding of facts, or the undertakings. Monetary remedies do matter, Sometimes they're small and appropriate to those circumstances. Sometimes there's large, like the $413 million involving Danske Bank last year. Accountability is also about individuals, not just firms. Last year, fully 2/3, I repeat, 2/3 of the matters we brought also charged individuals. Accountability includes protecting the public by barring those individuals, whether from practicing before the SEC, association bars, or otherwise. Last year, we obtained 133 bars of individuals from serving as officers and directors, our highest in a decade. That includes a 5-year bar on the former CEO of McDonald's, who made false statements about the circumstances that led to his termination. That also includes a permanent bar on a former Wells Fargo senior executive whom we charged with misleading investors about the bank's abusive sales practices. Don't get me started on crypto and holding individuals accountable. I won't even name all the individuals we've charged in this highly non-compliant field, crypto. I'm giving you a pause to think about the names yourself. I probably don't have enough time on the clock, so I'll keep going. Well, maybe I'll keep going if I get the page. High impact cases. When you're a victim of fraud, misconduct, abuse, the highest impact case is the one that affects you. Whether you lost $20,000 due to affinity fraud or your life savings in a crypto-related scam. We do not hesitate to protect investors, including vulnerable investors, such as by holding violators accountable for affinity fraud, including through a critical work of something we call our Fraud Against Minority Groups initiative. All cases are important, and that's why we work quickly to seek penalties and prophylactic relief to keep bad actors out of the markets. It's important to us that you in the audience work with your clients to create a culture of proactive compliance. There are also those cases that will garner attentions of lawyers, compliance officers and the like, and far beyond this room, and yes, often get reported by the press. Those sometimes are called the high-impact cases, though to any individual, the case that they've been defrauded in, that affinity fraud or crypto fraud, that's the high impact for them sitting in their lives. But these so-called high-impact cases, they also help change behavior and bring greater compliance with the law. Let me just highlight one such area. Since the 1930s, record-keeping obligations have been vital to the market integrity and the SEC's oversight. I think it was under Douglas in 1938 that we did our first rule on book and records. At a fundamental level, failures in record-keeping, like those involving off-channel communications, obstruct such market integrity. Since 2021, December of 21 to be more precise, in part through an ongoing sweep for potential violators, we have brought cases against 40 firms, required significant undertakings, back to that word, and ordered more than $1.5 billion in penalties. In the last fiscal year alone, we settled record-keeping related charges with 23 firms. Our actions uncovered not only the widespread use of personal devices and non-official channels to discuss business, but a complete failure of financial firms to maintain or preserve those off-channel communications. Now, why does it matter? It matters because it's how we maintain market integrity. It also matters because it's about how firms maintain risk management of what's happening at their firms. Further, last year we brought in rapid succession 3 cases against both public and private companies that used employee exit agreements to impede the employee's ability to file whistleblower complaints with the SEC. The exit agreements forced employees to choose between violating a separation agreement by providing information to the SEC or withholding information that could benefit victims of a securities laws violation. Well, that's a clear violation of longstanding whistleblower protections as adopted by Congress and in our rules. Look, some may say and call these high-impact cases regulation by enforcement. I just call it enforcing the laws and the regulation that are on the books. Fourth, process. Process is about fairness. We strive to be fair to those who have been wrong, those who we investigate, and the public at large. So we want to be fair to those who have been wrong, but also those who we investigate, and broadly the public. Process also is about timeliness, working to bring matters to a thoughtful yet expeditious resolution, whether that's to close a case and investigation or to bring it to a settlement or litigated matter. Process is about working with our partners in the federal, state, and international levels, as well as with self-regulatory organizations. And I thank all of our partners involved in matters from the recent fiscal year. Process is also about working with our most important partners, the public. The public's tips, complaints, and referrals are essential to our work as a cop on the beat. We received more than 40,000 tips, complaints, and referrals last year. Think about that, 1,500 to 2,000 a month. That included 18,000 from those critical whistleblowers that I talked about earlier, 1,500 or so a month. Further, process about meaningful cooperation. I'm talking about more than just showing up for testimony or producing documents under subpoena. It means going above and beyond to self-report, cooperate, and remediate. Across numerous actions the last fiscal year, the Commission ordered zero, I repeat, zero, or reduced penalties based on the respondents' cooperation. I hope that you might keep these actions in mind as you and the audience advise clients on the benefits of self-reporting and cooperation. Finally, process is about following the facts wherever they lead, whether it's to, again, close a case or, where appropriate, to go into court. We are not afraid to litigate matters, whether against the best resource founders, the oldest firms in this country, the newest industries, and yes, the largest crypto exchanges. Lastly and fifth, trust in the markets depends on gatekeepers. Gatekeepers like you all, gatekeepers like auditors, underwriters, and others. Think about what Douglas said when he was in that room some nearly 90 years ago in North Carolina about lawyers. When those in positions of trust abuse that trust, we will not hesitate to hold them to account. One example amongst others relates to an auditing firm called Marcum. Some of you might know it. Marcum is an auditing firm that took on more than 600 new clients that were special purpose acquisition companies. Now, to put this in order, it was a six-fold increase in just 1 year to their audit practice for the SPAC field. And if you just also want to put it, it was nearly half of the whole SPAC field in that boom-lit period back in 20 and 21. The strain of this growth exposed the firm's widespread quality control and audit standard violations. Marcum neglected its role as a gatekeeper, putting its clients and the investing public at risk. On top of imposing a $10 million penalty on Marcum for the violations, we required undertakings, limiting the firm's ability to accept new clients. In the last fiscal year, we also continue to hold credit rating agencies, underwriters, and lawyers to account. When we hold accountable those in a position of trust, I think that builds trust in our markets. Look, I started with quoting some greats of the securities field. You might think of Mr. Kennedy as a great in other fields as well, movie making, fathering a great family and everything. But Kennedy, Douglas, Frankfurter, and Marshall, four individuals critical to creating, shaping, and interpreting the securities laws that Congress established to protect the investing public and the issuing public. I hope all of you in the audience, when you're advising your clients, take those leaders' words to heart. I know that they're your clients. I know that it's kind of neat and it's like a riddle and a puzzle to sort of say, how can you do combat against the SEC? I know that. You went to the finest law schools in America probably to be trained. And it's kind of an interesting field that you're in. It's not without its interest and challenge, but please remember some of these words of the founders of the securities bar as to what they were saying, too, about the public and about protecting issuers and investors. I know the dedicated staff of the SEC do this. I couldn't be prouder of the staff in enforcement and beyond every day to live up to the words and spirit of these quotes. I thank you. I thank them for their work. I thank you for listening to these remarks. I thank Bruce, who's going to be kind with his questions. Or maybe he'll rough me up a little bit. But Bruce. You want more?
Well, thanks so much for sticking around to handle a couple of questions. We have another 15 minutes or so. I have a bunch of questions. We'll get to as many as we can. A lot of them were collected from the people in this room. Let's start with crypto, just because that's what we have to start with, right? So the SEC claims...
You don't actually have to. You know, we have a $110 trillion capital market. 110 trillion, roughly. Crypto worldwide might be $1 trillion, but in the U.S. is less. So just by the math, it's well less than 1% of the U.S. capital markets. But go ahead.
Right. Well, there are a lot of questions about it, so we'll knock it out quickly and move on. So the SEC claims our doors are open, come work with us to get into compliance. The crypto firms don't like the message they get when they do make an SEC visit, apparently. So how do you respond to criticism from the crypto industry, I guess elsewhere, that the SEC refuses to engage in productive discussions about how crypto can effectively operate in compliance with the securities laws and regulations? I think Matt Levine of Bloomberg summarized it as enjoy London, but that's probably not the response that you would give.
No, I don't recall reading Matt's thing about London, but I've always loved London. Look, I'd say this. You know what the laws are. You may have a non-compliant client who's not doing the proper disclosure on their crypto security token, or an intermediary that's commingling so many functions that it's just rife with conflicts. And so, but we would never allow the New York Stock Exchange to do the things, or a hedge fund, or a broker-dealer to do the things that crypto intermediary may be doing. You all are practiced in this field. And so I would just say to think through and say, I get it. It's like, this is not what the securities laws are about, and protecting the investing public in this like bundled product where, you know, all too often the investing public doesn't get disclosure, might be trading against the house, and if the house fails, it's just lining up in bankruptcy court and doesn't have proper segregation. So, yes, we want to work with folks to get into compliance, but it also starts with whether that crypto intermediary or that crypto securities asset provider wants to come into compliance.
Are there any best practices that somebody could follow to actually, you know, successfully come in and work with the SEC that you could mention? Yes, I mean, come in and actually recognize. I mean, part of it is like what I said earlier, more broadly about cooperation. But in this field, it is really rife with non-compliance, and not just with the securities laws, with the Bank Secrecy Act, with the Commodity Exchange Act, which I know something about and love. That's a great agency as well that I was honored to chair. So the challenge is like the basic underlying premise of this field was we're going to be, you know, as Satoshi Nakamoto wrote, you know, purportedly decentralized, even though this field is not so decentralized. It's in fact rather concentrated, and outside of government intervention or government oversight. Last question on crypto, I promise. So can you offer a guess on what the crypto landscape, crypto regulation might look like in 3 to 5 years?
I think it's this, at least on crypto securities regulation, is you know it. You know the 33 and the 40 Act and the 34 Act. You know what the rules are. We've put out to public comment a number of things around exchanges that is far broader than in crypto, but you might know this proposal around Alternative Trading Systems -G, ATSG. We've put out things on best execution, again, whether it's stocks, bonds, or crypto. we've put out to public comment some things around safeguarding or custody. Though today, and make no mistake, today the custody rule from 2009 already applies to many funds and crypto securities. Today, the definition of exchange already applies if you're operating as an exchange in this field.
We'll change the subject to dissents by the commissioners. And the SEC veterans, the followers who are here today, know that the commission, especially on important rulemaking, important enforcement matters, used to speak with one voice, clearly, often unanimously. And today, the public dissents by certain SEC commissioners seem pretty much routine. And my question is, what do you make of all the dissents? And have you given up on trying to find consensus or make compromise on the rules?
Liz, this is the greatest privilege of my life, being the chair of the Securities and Exchange Commission, but I had another great privilege of being the chair of the Commodity Futures Trading Commission. I even chaired a commission in Maryland, a Financial Consumer Protection Commission in Maryland. So I don't know, I might be growing up as one of 5 children or having an identical twin or being a partner at Goldman Sachs. It's collaboration, it's teamwork. The public benefits from the commission structure. I benefit every day, the staff benefits by 5 independent policymakers on our commission. And sometimes we come into consensus, sometimes we don't. But even when we don't, our doors are open to each other. We talk a lot. We narrow things. And I would say every rule and enforcement matter that I've worked on at the commission in my 2.5 years benefits from that sort of back and forth.
But do you feel like the constant dissents kind of dilute the message of the case or the rulemaking?
I understand your question, but to me, it's not about a message. It's about the authority that Congress has given us, our 3-part mission. Investors, protecting those investors, facilitating capital formation, and ensuring that the markets in the middle work, fair, orderly, efficient. Most of what we're doing is around that middle. Our equity market reforms that we've proposed, our treasury market reforms, private funds. It's about that middle working more efficiently, more resiliently. And again, I think we benefit the back and forth that we have amongst commissioners. I mean, you could see it last week, and we were kidding around about my birthday, but I think we really like each other. We just differ. And this is America. This is democracy. I mean, I don't know what's exactly going on right now up on Capitol Hill, but there's some differences there too. So I don't think we should be anything, but that's democracy in action.
Let's switch to administrative proceedings. So the APs have been under attack as, I guess, unconstitutional in some recent cases, one of which is headed to the Supreme Court. So what do you make of those challenges, and what happens to the enforcement program if the Supreme Court does away with administrative proceedings?
Well, I think I'm going to leave it to the Justice Department that represents us in front of the Supreme Court, and they'll probably, I think that oral argument's already scheduled. You all might know this case in Jarkissi, so I think I'm going to
leave that one?
Well, to my lawyers.
Okay.
We too are represented by some, and they're really good lawyers under Elizabeth. That's the Solicitor General.
So I think it was last week you stated that, in your opinion, a financial crisis caused by artificial intelligence is nearly unavoidable. Those are your words. And in the next decade without further regulation. And I was wondering if you could elaborate on why you think that and what kind of regulation you think would be helpful.
Look, I think that the changing I'm a bit of a math guy. Rob and I were at least mathletes when we were kids. I love the math around machine learning. I spent a little bit of time, more than a little bit of time at this at MIT. Predictive data analytics and AI are already changing the face of finance, and way before generative AI, being used in all sorts of ways already, compliance and algorithms and the like. It's going to lead to greater efficiency. I think it will transform our economy as big as, automobile revolution in the 1920s. But I do think that it's going to lead to concentrated nodes in the financial system. I think that we're going to see 2, 3, maybe at most 4 base foundation models, and the economics, the network economics of it are pretty dramatic. Look, we really we have 3 cloud companies in the U.S. 3 big cloud companies, each of them aligning with one AI, generative AI. But this is even more powerful network economics than that. Data aggregators. If you have one really solid big data pool of the right mortgage data, everybody's going to have to go to that data aggregator. I think that's nearly unavoidable that you'll have that concentration. So what that then leads to is the two of the 3 things all the academics write about financial instability. They write about herding, whether you have, basically everybody's herding in the same direction. They write about network interconnectedness and regulatory gaps. And I wish I could tell you otherwise, but I think that we're going to lead to some monocultures in the financial sector. And a bunch of fintech startups and other companies, even the biggest financial firms, will be relying on some aggregated data pool or some foundation model somewhere. And it will be herding and network interconnectedness, coupled with ultimately a regulatory gap, because most of our regulations are about institutions. They're not horizontal. They're not looking at those codependencies. So yeah, I think the after action report in 2032, I'm not predicting it's 2032, but could well be, oh my, everybody was relying on the same model. And by the way, those models get stronger and stronger each year, but they also get stronger by all of your uses.
We have about 2 minutes left, so I want to ask you a question about your legacy as chairman. So when your term is over and you're looking back at your SEC tenure, what specific initiatives or accomplishments do you hope that the securities bar, like the people in this room, will remember you for?
You mean other than this fireside chat?
Yes.
Look, I'm just focused on, again, it's not hard to tell. I think it's a remarkable privilege to serve. Any of you, if some of you are SEC alums, but if you've served in government, in any administration, it's a remarkable privilege. So I just look at it through taking the time. We get 5-year terms, but taking the time in that term to do as much good for that our client, the American public, 330 million Americans, as investors and as issuers. And that's what we're trying to do. In everything we do in the rulemaking side and in the enforcement side, and ultimately on the enforcement side, it's about trust in the market. And the more that folks trust a market, that lowers the cost of capital for issuers, because you take out some of the risk premium. The more you trust in markets, the better investors can participate and more households participate when you can trust a market. That's what we don't have in the crypto market. It's what we generally do have in the rest of the markets, but it's trying to drive greater efficiency in what we have. And in the enforcement side, I just hope that every once in a while you pause and say, I know I have a client, but I also have this sense of what really is the law? What did these greats who wrote these laws? And it's not just the greats from the 30s. What did Paul Sarbanes try to do in Sarbanes-Oxley? What did Chris Dodd and Barney Frank, what did others do at different times and write these laws? And really get to the essence of those laws and say, yeah, I get it. I should advise my client. We should stay within the chalk lines and not be sort of skipping around on the edge of things. Listen, I worked at Goldman Sachs for 18 years. I asked for the memos from Sullivan and Cromwell and Wachtell Lipton and Fried Frank. My God, Arthur Fleischer was terrific. And some of those memos about, well, if you just You just do it this way. You set up 3 more legal entities and you put one of them in this jurisdiction and you put this over here. Not only will you be able to get this regulation, this tax treatment, but you might even throw in a little bankruptcy remoteness too. Like, I know that. We did it all legal, by the way. But I think it's still trying to think about what is the kind of core of our securities laws. It's about investors get to decide what risks they take as long as they get full, fair, and truthful disclosure. Roosevelt called it complete disclosure. He called the 33 Act the Truth in Securities Act. Came back with the 34 Act, of course, because you had to regulate exchanges and broker-dealers. Came back with the 40 because of investment advisors. That's what it's about.
Yeah.
But I'm just thinking about moving some good product across the line for the American public.
That's great. Well, we're really grateful for your remarks earlier and for taking a few questions. So thank you so much for being here. And please join me in thanking Chair Gensler.